Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we are again talking about the bankruptcy code and how it is being perverted in multiple ways. Those of you who've been watching this video blog regularly would have seen that for the last 3 or 4 weeks, we have discussed bad loans and we have discussed bankruptcy. This time, it is just bankruptcy because we have a terrific order from the National Company Law Appellate Tribunal that in detail exposes the dubious collusion between a defaulter company, Hirakud Industrial Works, and the creditors, which has come out because there were 2 people who actually protested and filed an appeal. Now, that part is very rare, and that's why all this is in the public domain for you to know step by step what is happening. So the shameful collusion between creditors, resolution professionals, now, or I'm going to keep calling them RPs, these are the one-person sutradhars who are supposed to vet all the documents, talk to creditors, talk to the bankrupt company, and ensure that the bankruptcy code is followed in letter and spirit. They play a crucial role, and if they side with one of the 2, the creditors or the company, a lot of damage happens, and this has been happening regularly. Now, the most recent case that we're going to talk about in this video is Hirakud Industrial Works. I'm going to keep calling it Hirakud, which was stopped, like I said, because of the efforts of Hindalco Industries, which is part of the Aditya Birla Group, and a strong workers' union, Hirakud Workers Union, which has been waiting for its dues from, hold your breath, 2006, and they haven't been paid. Okay, so they've gone to the Supreme Court, they've gone to the High Court, and they were here to actually file an appeal. Otherwise, none of this would have happened. The sale would have just gone through. So what really happened? There's a bankrupt company, which is a part, which was a former public sector company, taken over by 3 private companies. This colludes with a so-called creditor, and I'm saying so-called, I'll explain why, with a resolution professional, obviously helping grease this dubious process. Now, like I said, sources say this happens regularly. It has only come out this time. I need to stress on it because of an order of the NCLAT, and we as a media entity are able to talk about it. Hindalco filed an appeal along with the workers' union, which led to an order on 9th Jan 2023. So it's very, very recent. And here's what happened. NCLAT set aside the resolution process, which means it was just rolled back. They called it, declared it non-est, as is, has it happened at all, completely rolled back to original. There was a successful bidder who had paid 40 crores, who was part of this dubious cabal, so that money will be repaid to this creditor. What it has done is imposed a penalty of 50 lakh each. Under the law, under the bankruptcy law, section 65, there is a penalty of up to 1 crore. This was split between 2, Hirakud Industrial Works, which is the defaulting company, and the ostensible financial creditor, whose name is Nandakini Contractors. Keep this in mind. It also directed the Insolvency and Bankruptcy Board of India, which supervises the whole act, to conduct and complete an investigation into the actions of this resolution professional, who in this case was a man called Anand Rao Kurada. This has to be done within 3 months. Now that you know that there has been tough action, let's hear what the story and what the fraud was about. So Hirakud began operations as part of the Odisha government, which had a public sector entity called Infrastructure Development Company. Hirakud was part of it. IDC, sometime in 2006, divested its entire holding to 3 private companies, Varsha Fabrics, Mudrika Commercial, and India Finance. Part of the deal was that they were supposed to settle the unpaid dues of workers. So as you can imagine, Hirakud was already having serious financial difficulty and not been paying workers. These 3 did not bother to pay the workers, so the workers' union went to court. This led to a tripartite agreement, which was signed by the 3 new owners on the directions of the Odisha High Court. Way back in 2006, at that time, a labor court had crystallized the pending dues at huge amount, 45.67 crore. This had to be paid under the tripartite agreement. What did the new owners do? They didn't want to pay it. So they sold their entire holding in 2007 to a company called Indo-Wagon Limited. And they shut down the Hirakud factory. So now the workers are high and dry. They have no option but to keep fighting in court. The company first bought by these three, sold to a third company, and that company also now is not willing to pay. Factory is also shut. So what did the union do? They went back to court. The court battle was, like everything in India, humongous, long drawn, has carried on for 15 years. I'm not going to go into details because it's not relevant to our story. But suffice it to say, the workers' union had to go all the way to the Supreme Court, come back to the High Court, go back to the Labour Court. There were all kinds of difficulties in between, but the courts basically issued orders to say, sell the land belonging to Hirakud, sell assets, and pay the workers. Okay. This was, the last order was on 8th April 2019. Now, several pieces of land probably would have been sold. One actually got sold to the government waterworks department and brought in 10 crores. So the amount to be paid to workers reduced by 10 crores. Another piece of land which was to be auctioned was a private railway siding, which was already being leased and used by Hindalco. Now, Hindalco obviously bid for that land because they wanted it. It emerged as the sole successful bidder, but was willing to pay only 15 crore. Obviously, this was not good enough to even get the workers' dues. 15 plus 10, not good enough. So the workers went back to court and challenged it, and a re-auction was ordered. Now, while all this is going on, endless litigation, go to the Supreme Court, go here, go there, challenge that. While this is going on, something else happened, which is, remember, Hirakud is now owned by a private company. They decided, let's find a way to keep this within ourselves and keep the bidders out and keep the workers out. So what did they do? A company called Nandakini Contractors comes out of nowhere and says that, hello, you owe me money. It is ostensibly a creditor, and it tells Hirakud, you owe me 14.51 lakhs, which we have lent to you in March 2016. There is apparently not even a loan agreement, but in a great hurry, lots of things happen. Hirakud and this contractor decide that we'll form a committee of creditors. They appoint this man, Anandrao Kurada, as an interim resolution professional, later convert him. He quickly, in a big hurry, approaches what is called the adjudicating authority, whose job it is to look at whether there is a case, whether there is a liability, which is acknowledged, and then allow bankruptcy proceedings to start. So the adjudicating authority said, where are the loan documents? Asked Kurada to produce them. But eventually, without waiting for any of this to actually happen, confirm it, in June 2019, the adjudication authority says, okay, resolution proceedings will start. Now, Nandakini Contractors is the main creditor. There are a whole lot of other companies. I'm not going to get into names because it doesn't matter. It's very complicated. But a whole lot of small companies who jump on and say, we are now part of the committee of creditors. Everything is moving in a cheering hurry. Why? Because a second auction is held. Hindalco bids again. And before that auction is completed, this company, thanks to Nandakini Contractors' action, is admitted to the resolution process. Now, the way the Bankruptcy Act works is this, that the minute an adjudicating authority says, yes, insolvency proceedings can start, it has to then go before the NCLT, National Company Law Tribunal. But the minute this starts, a whole lot of things kick in. One is there is a moratorium on all sales, credit, loans. Nothing can happen. Nobody can go ahead and claim money except when cleared by the NCLT. So things come to a standstill. Hindalco is obviously curious because meanwhile, so two things are happening. One is Kurada is moving rapidly along with this bunch of creditors to ensure that the resolution process is done double quick. Hindalco says, give us details. What is this loan? Who are the people who have shown interest in buying this company? And Kurada refuses to give any information. he's required to do so. He is required to give as much information because he's a facilitator. He has a fiduciary responsibility, but he doesn't do so. Meanwhile, he says that a company called Regus Impex has turned up, willing to pay 40 crores, and it is a successful bidder because apparently there must be no one else. So he goes to the adjudicating authority. He wants all this ratified by the NCLT, which ratifies it in 2021 and says, okay, Regus Impex is the winner for 40 crores. They're going to get this company. What happens to the workers? Don't ask. They're not getting paid. So Hindalco and the workers union separately decide we're going to fight this. They go to the appellate tribunal. Hindalco, meanwhile, does a lot of homework. It pulls out documents. It looks at who the creditors are. It looks at what this contract of Nandakini Contractors is, and discovers that there is no loan that's even listed in Nandakini Contractors' own annual report. There is uncertainty even about the date of default. What is the date on which Hirakud stop paying? Did they really pay? Were they not able to pay? What is worse, NCLAT later noted that Mr. Kurada had even signed an affidavit prepared by a director called Sucheta Dalal of Regus Impex. Now remember, Regus Impex was a successful bidder. He said that he is not a related party of Hirakud, which was a complete lie because this man, Sucheta Dalal, was on 5 companies, on the creditor's side and on the buyer's side. All this was proven with official documents and public records by Hindalco in court, in the appellate court. Of course, the resolution professional said he signed it inadvertently and nobody is getting into the criminality of it. All said and done, nothing that was to be done as in checking whether there was a loan agreement, whether there were dues, whether this was a secured loan, nothing had happened. Things were being pushed through to sell this company at 40 crores. What did Hindalco's investigation find out? Remember, Hindalco is not alone. The workers union also did a lot of finding out. They had a senior advocate in court who made a lot of points. I'm going to summarize all of them because we are only showing in this video blog how dubiously people collude to pervert the Bankruptcy Act. So first, Hindalco said the constitution of the COC itself was illegal since creditors, whole lot of ragtag 5-6 companies, each holding shares in another. They produced charts before NCLAT to show that they were all related parties. One holds a big stake in another, the other holds a big stake in the third. One of them is a holding company which also owns Hirakud, established in court during the resolution hearings. It, in fact, did it even before the adjudicating authority, but it was, as the NCLAT order says, inexplicably ignored. Why did it not ask for investigation into the role of the adjudicating authority? We will never know, but it has got away. Second, Nandakini Contractors could not show any bank statement to prove that Hirakud owed it 14.51 lakhs. There was no loan agreement, and in this hearing, it did not even participate. Hindalco claimed that the resolution process was begun on a false and imaginary loan. Think of it. Since it did not find mention, as I said earlier, in Nandakini Contractors' annual report. Now, Hirakud and Nandakini Contractors, so the guy who is defaulting and the guy who he owes money to, entities, okay, in joint haste pushed through the resolution, smacking of collusion to defraud workers, who are the only losers on this, the workers who have to be paid 45.6 crore. The adjudicating authority, I will again stress, had asked the RP to file copies of claims received from the financial creditors, proof of debt, etc. It was not done, but it went ahead and allowed the resolution to happen without insisting on it. What did Hindalco's chart show? Apart from the interconnected shareholding and cross-holding, they also showed common directors. So this Datta Roy was one who was on 5 companies, apparently. Email IDs were the same. So they were closely connected to the corporate debtor, and the successful bidder was also closely connected with them. Same group of companies. Why so many companies are allowed to be set up as subsidiaries? God alone knows. This government had said it's going to stop it, but it's not happening. Again, like I said, there's no need, it just complicates it to go into each level and each chain of how they were interlinked. But NCLAT has noted after hearing Hindalco that the linkages between the corporate debtor Hirakud and the successful bidder, which is Regis Impex, is quite apparent, which has been brought out in the chart submitted by the appellant HIL, which is Hindalco, which has been included in the judgment. So those of you who want to see it can take a link to the judgment and look at it. The NCLAT also was very clear in saying this. It said the nature, involvement, and conduct of the companies led to the inescapable inference that they were acting in concert and being guided by someone as part of a fraudulent project to defraud the creditors. In this case, creditors being also the workers' union. They were misusing the spirit and objectives of the bankruptcy law in a manner that cannot be condoned or overlooked. The sordid saga raises several questions. One, this battle has gone on, it has been rolled back, so now Hirakud remains as it is. But what happens? Will the management of Hirakud, Nandakini contractors, and all the entities that were part of this deal get away unscathed, just paying 50 lakhs and end of the story? This is sum total of the penalty under Section 65, 50 lakhs and 50 lakhs. Yes, there is an investigation. We don't know whether it will lead to the resolution professional facing any criminal action, because this is a criminal attempt to defraud people. And the action has to go beyond the NCLAT order. Question is, who will initiate the action? Should it be the workers' union who have still not been paid? Will they have to have another long battle, go back to the Supreme Court to get their pending dues? Because despite repeatedly approaching the Supreme Court and the High Court, the story is not over. In fact, now that it's gone back to status quo, they may have to again go into an appeal, again fight to say who pays the money. And with all the time lost, this amount that's crystallized, 45.6 crore, what about interest on it? What about the cost of the legal battle? If you want to get a senior advocate, it costs a bomb. Who is going to pay all of this? Nobody talks about it. Finally, it's all very well for Hindalco to have fought this great battle, but will it bid for Hirakud, the whole company? And will it pay enough to give a fair deal to the workers? Because remember, the last one was being sold at 40 crores. The workers' dues alone are 45.6 crore. Unless there is a fair price from Hindalco, it means that after entire fight, those who have lost out because of the slow dragging legal process will continue to be losers. Because over a period of time, the land, the assets, and everything else that Hirakud had would have reduced in value, would have degenerated, and nobody is responsible. We can't have a bankruptcy law that works like this. We can't have a legal system that works so slowly, because it only defrauds not just companies and creditors, but the country as a whole. If you agree with this, please share this video. Thank you.